The real dispute comes down to the question of when someone says, as Javier put it in his points, that because of my religious beliefs, there's something I must do or there's something I must refrain from doing. There's an action that I have to take or an action that I have to refrain from taking because of that religious or conscience-based view. That's really where the action is. So what I want to do is focus on a particular slice of history, which is looking at a handful of different situations in which the state or federal laws have either required people to participate in killing or at least permitted people to participate in killing, and just talk about how conscience has been understood in those contexts. So first and foremost, to start with the most obvious one, conscientious objection to military service. There's a long history, older than this country, of sort of pre-constitutional colonial governments affording some level of conscientious objector protection. That protection was not complete and it was not perfect. Sometimes the conscientious objector had to be willing to hire somebody else to go fight in their place, which many Quakers, for example, thought was also a violation of their religion. So it certainly wasn't a complete protection. It also wasn't a complete protection because it only applied to members of specifically recognized peace religions, like the Quakers. So if you happen to be a Catholic who objected to military service in 1780-something, you would be out of luck. That's where the conscientious objector treatment started. Over our history, though, it's been expanded quite a bit, so that now it is not at all limited simply to members of certain organized religions who say, here, let me show you the express doctrine of my Quaker church that says I can't do X. It's actually open to anyone who has a religious objection. And then in the 60s and 70s, both the Supreme Court and then Congress expanded it even further to be not simply religious objectors, but also people who object out of a deeply held moral or philosophical belief. So that's what's happened with conscientious objector provisions related to military service. What's interesting is that over the past 50 years, we've seen a handful of other situations where the state allows or compels people to participate in killings, and we have seen the development of very similar conscience clauses, allowing people to opt out. And in many of the cases, it has followed the same trajectory as the military service cases, in that it protects not simply religious objectors, not simply people of any particular faith, but actually anybody with a deeply held moral or philosophical objection to participating in the killing. The best example of this is the abortion context. Right after Roe, at a time when our country was and still is, right, deeply, deeply divided about the morality of abortion. One of the things that happened very quickly after Roe was really broad, widespread agreement, both within Congress and at the federal level and across the states, that, well, while this is going to be something that is legal, it's not going to be something that you can force unwilling people and institutions to participate in. A handful of places limited that to religious objectors. Most of them didn't. So at the federal level, we have something called the Church Amendment. That is anybody who refuses to participate in abortion for any conscientious-based reasons. Later, federal protections don't even refer to the reasons at all. They simply say if you refuse to participate. So it doesn't say it's got to be from a deeply held moral or philosophical or religious basis at all. It's simply a refusal to participate. The same thing has happened in two other areas. One, capital punishment. Capital punishment. Many states don't have the death penalty. Many of the places that do have the death penalty, including the federal government, have created express conscience protections saying that if you are unwilling, at the federal level it says religious or moral, again it's a broader view of conscience, religious or moral reasons, you can't be forced to do it, even if you are a corrections department employee. In other words, there's no concept here that, well, you went into this field, you gave up that right. You chose to work at the penitentiary that does executions, you're out of luck. In fact, it's the exact opposite. It's an express conscience right for people who work in corrections facilities not to participate. And that's been duplicated in, I think, 11 states now have similar provisions. Some of them talking about religious and moral objections. Many more of them just saying it has to be voluntary. We're not going to force anybody who doesn't want to do it to do it. I think those are all terrific developments. I think it's a very good thing. At some level, non-religious-based conscientious objections don't get the same protection as religious objections do. We have a free exercise of religion clause, not a free exercise of philosophy clause, so there's some manner, although I would say, according to the Smith Court, there's not a whole lot of work that gets to be done by that clause, or at least not enough, according to my view. And we have statutes like the Religious Freedom Restoration Act that provide broader protection for religious objectors. But at least in these areas where someone could be asked or compelled to participate in a killing, we've actually been pretty good over time at saying we're not going to force unwilling people to do that. In fact, despite all the big fights about the Affordable Care Act that are going on in the courts, many of which I'm actually involved in, one thing that's great about the Affordable Care Act says no individual or healthcare facility can be discriminated against based on their refusal to participate in abortions. It doesn't limit it to religious objectors. It doesn't make the claim that a facility can't possibly have a religious conscience about something. It simply says you don't have to do that. I think that's a great thing.